DACA recipient and employment-based green card. In this video, I am going to lay some foundations for you so that we can help a DACA recipient get the green card or apply for an immigrant visa. Let's get started. If we're gonna talk about two scenarios here, or three, right? So a person enter with inspection, that's a DACA recipient, either under B1 or F1, and perhaps F2 because the person is too young. They come under their parents, right? And they get DACA prior to turning 18. So which means that those prior years, because the person is a minor, that person did not accrue unlawful presence, right? There's no unlawful presence being accrued. So now the person is self-sponsoring, or the employer is petitioning for the person. How is it going to play out? So the person is going to apply for the employment-based type of a petition, I-140, if the person is here in the United States, of course, I-140. If the person is temporary outside of the United States, maybe they will file I-129. But let's go with the scenario when the person is here, physically present, right? I-140 is filed. So once the I-140 is approved, what is going to happen? If the person is still under F2 type of visa, combined with DACA, of course, and they're still going to school, they didn't violate their F2 visa, then the person will be able to adjust status inside of the United States. However, the person who did not continue to have their F2 visa in place, like the I-20 has expired and so forth, what's going to happen is this person is going to have to go through consular processing. Let me tell you why. The reason why the person is going to have to go through consular processing is because DACA is deferred action, right? It does not confer legal status. And one of the requirements for adjustment of status is that the person must be within lawful status at the time the adjustment is filed. So even though the person did not accrue unlawful presence, the person is still not legal, especially in the light of that Supreme Court decision and the Fifth Circuit decision and the appeal that confirmed the Fifth Circuit decision, which simply stated that DACA is illegal. It makes it hard to adjust status even though the person did not accrue unlawful presence, because DACA is deferred action, does not confer legal status. Therefore, the person has to go through consular processing. But the good news for this type of person is that because prior year before turning 18 does not count in terms of unlawful presence, they did not accrue unlawful presence, and the fact that they have continuously filed their DACA after turning 18, then that person did not accrue unlawful presence even after turning 18. Therefore, if that person goes outside of the United States, that person will get the immigrant visa, okay? Immigrant visa from outside. And what's gonna happen is you monitor the visa bulletin when the dates of filings are current or when they are available. Then you file to NVC. Of course, your case is going to be transferred because that's what you're going to write on your I-140. And when it's time to file, you file. And then when the interview schedule, you get out and go. You can take emergency parole because you're going for an interview, and you can get emergency parole. In most circumstances, they'll give it to you. Then you go and get your immigrant visa from outside, okay? Then the second scenario, this is the scenario really I want to focus about here, is the exemption and the exception. Say that the same person has an exception under 245I, which we already know what it is. If the person has a petition that was previously filed for that person, that will be family-based because the person's too young at that point, right? Family-based that was filed on or before April 30th of 2001, then that person will take that petition and use it to waive all the inadmissibility issues in terms of unlawful presence, legal status, and that just in the United States. And if the person enter without inspection as well, right? So, but the exemption here, I wanted to talk about it in terms of, let's say the person went outside of the United States. Let's say the person was qualified for H-1B or L-1B visa. You know, those are temporary work type of visa. So the person, eventually they have to get their visa outside of the United States, except for this new program, right? For H-1B visa holders who can actually get their visa inside. That's a new program. But we are assuming for the purpose of this video that this person never got and they've never received an H-1B visa before. So what's going to happen is if the person goes outside of the United States and the person comes back, that person later on, if they get EB2 and want to adjust status under EB2, if EB2 is approved, because the last entry is going to be with H-1B visa, and each H-1B visa has a dual intent, so they can in fact adjust in the United States. Why? Because we're gonna go with the last entry, and the exception under 245K says that the lawfully entry, and as long as the unlawful presence is less than 6 months, work authorization less than 6 months in aggregate, that person can adjust status. Okay, that's exactly how it's going to play out. So it's a little bit complicated. That's why you need counsel. You're going to have to, because we're going to have to assess your case and look at those unlawful presence, how you got here. If you enter without inspection, that's, we already know you're going to have to do consular processing and get some type of parole. But we still have to calculate those unlawful presence. But just know that if you didn't fail to maintain this immigrant visa, non-immigrant visa, either it's H-1B or L-1 or F-1 or F-2, if you fail to maintain it, then you're going to have some type of challenge when it comes to adjustment of status. Previously, we were able to do it for some Daca applicants with the one that came with F2 visa, because there was some type of loophole where we were able to, you know, explain our way out of it, and they were able to adjust status inside of the United States. But with this new guidance and the recent decisions, it's pretty much impossible, because, you know, deferred action, no legal status is conferred with it, although you do not accrue unlawful presence, but still you are not within lawful status. So there is a difference between unlawful presence and legal status. So if you need a consultation, we always encourage you to schedule one by using the consultation in the description links below. And the reason you will need it is because we're going to have to access the entire case and really provide you with the best possible advice so you can file and get your green card. By the way, USCIS is going to increase the fees. We already know that starting April 1st, 2024, if you're eligible for any type of petition, this is the moment. And as a matter of fact, you should file it at least by March 15. That's the latest, because you have to take time too. You know, sometimes the application gets rejected, so you have time to maneuver all that so that you can use those old fees. April 1st, 2024, my friend, everything's changed. It's going to change for the worse. with those pricing. But we're here to help. If you need a consultation, again, please schedule it by using the consultation link in the description box below. Until next time, bye-bye.